to have them around. We'll just do a little bit of opening sessions when the judges come in, and it's going to be a little brief because we are behind by almost an hour. We also take note of the fact that it's a Friday, people go for prayers, but we'll try to manage. Also, there's a mosque here, so if you're not mooting and you want to do your Juma, just behind here there's a mosque. But we want to really get out of this room latest by 2. So when our judges come in, please, let's stand and welcome them in. They're just doing a photo moment. Also, don't be on pressure. Don't be on tension. Mooters, just calm down. They're just like the ones of yesterday. Okay? Just calm down. And be yourselves. And we wish you the best. You're going to make it. Yeah, so we'll just wait for a minute. Let them in. Then I'll let you know what the next session will be, will look like. Thank you so much. Good morning once again. Our honorable judges, your lordships, we really want to welcome you to this 10th MOOT that is comprising of universities from across the country. We will spend less time on opening, and I kindly allow me to invite the Executive Director of the Center for Health, Human Rights and Development to just give us opening remarks and a brief about the MOOT and bring you to context and speed to the MOOT. And she will spend just a few minutes, and then we'll also welcome the Minister of Health representation. She will do that before opening up to the actual mooting. Ms. Fatia Chiange.
Yes, thank you so much. Our Master of Ceremony for the day. Good morning to us all. Good morning. Yes, the Honorable Principal Judge, Honorable Justice Dr. Flavian Zeija, Honorable Justice Mike Chibita, Honorable Lady Justice Eva Luswata, Honorable Retired Justice Wilson Kwesiga, Honorable Lady Justice Victoria Nachintu Katamba, the mooters, the MOOT coordinators from the various universities and the lecturers, our partners, the media representation here, and all our invited guests, the Minister of Health representation, Dr. Charles Solaro. Allow me on behalf of the Center for Health, Human Rights and Development to take this opportunity to warmly welcome you to the 10th Annual National Inter-University Constitutional MOOT Court Competition this morning. And CEHAD was established 13 years ago to pioneer the justiciability of the right to health by advancing social justice and human rights in healthcare systems here in this country, in Uganda, within the East African region, but also with regional impact and global impact. So This work goes beyond the boundaries of our country, but also we know that healthcare systems are impacted by social determinants of health, and indeed, for us to realize good health and well-being for all people in this country, especially the most vulnerable, we also go beyond the health sector and look into the education sector, gender, agriculture, financing, because all those are important for us to realize the right to health in the country. We have hosted annual MOOT competition since 2014, and this is the 10th one. And it's an event we look forward to with enthusiasm each year. Through the MOOT, law students are inspired and nurtured on the art of advocacy and the practical aspects of litigating the right to health in courts of law. Having litigated several cases since by 2014 then, we realized that the right to health is one of those rights which does not have specific provisions in our constitution in Uganda, but are inferred from national objectives and directive principles of state policy and a few provisions thereunder, such as the right to life. Universities had also by that time started offering courses like health, law, and policy as alternative course units, and were impacting society positively once these students qualified from such courses. SEHAD, for example, was founded by a student of such a course which he had undertaken at Makerere University 20 years ago with the support of his law professors. Through the MOOT, we are able to inculcate a culture of advancing the right to health to the students, including those who may not have had an opportunity to take such a course at the university. The MOOT is also designed to build your capacity, the student capacities in actual aspects of litigation, including court decorum, actual court setups, and the judiciary. It also develops the legal research skills of the students, as you'll hear from them. We work with the judges and magistrates from various courts within the country to preside over the MOOTs. We are grateful to you honorable judges and the magistrates for accepting to collaborate with us in this journey of nurturing young lawyers who can choose to advance social justice for the most vulnerable members of our society. Through the MOOTs, you are able to expose the students to real court experiences of litigating the right to health in the country and internationally. The competitions expose students to litigating cases before the High Court, the Court of Appeal, and the Supreme Court of Uganda. This year's MOOT competition focuses on access to life-saving information as a key component of realizing access to universal health coverage for sexual and reproductive health and rights, as well as gender justice for young people specifically. The MOOT has allowed students to dissect the extent to which the lack of information on sexual and reproductive health bears a ripple effect on the right to education and health in the country. A total of 16 universities expressed interest in the MOOT this year, and 11 of those from across the country were selected to take part in the competition. These are here with us today. And the universities that were selected to take part include Cavendish University, Uganda. If you're here, you can wave for recognition. Gulu University, yes. International University of East Africa. They were with us yesterday for the preliminaries. Islamic University in Uganda. Kampala campus, the females campus, Kaboja, and the main campus in Mbale. Kampala International University. Makerere University, Nkumba University, and the Uganda Pentecostal University, Fort Portal, and Kampala campuses. Would like to appreciate you for taking part in this year's MOOT competition. SEHAD appreciates these universities for continuously engaging in the MOOT. We also extend our sincere appreciation to the leadership of these universities for providing support to the students through their MOOT coordinators to enable them participate in this important annual event. With those few remarks, I would like to wish you all a great and impactful experience from this final competition today. And allow me to invite Dr. Charles Solaro, the Director of Curative Services in the Ministry of Health of Uganda, to also give us a few remarks, because the issues that are of focus for this MOOT competition are issues of health. So it's important that the Ministry of Health is here with us, and also it is very important to know that in a practical sense, the judiciary works closely with Ministry of Health. That's very important, because we cannot realize the right to health if the two are not working in partnership. So welcome, Dr. Lara, and we are really happy to have you with us today. Thank you.
Thank you, Eddie, the Honorable Principal Judge, the Honorable Judges, the MOOTers, the coordinators, the Executive Director, and the staff of SEHAT, all guests, ladies and gentlemen. It's a pleasure to join today in this MOOT competition. I have been privileged to actually attend three sessions. I am here. First, I want to emphasize that the government of Uganda is committed to ensuring access of all people to high quality of health care services, and all of us know that this is granted in the Constitution of Uganda, the Social and Economic Objective 20 of 1995. As has been mentioned, you cannot achieve health without definite respect of human rights, and ultimately with the extension that any country cannot develop without those two. So you need health rights, you need human rights, but to be able to achieve wealth, as is our motto, that health is wealth. So I just come here to represent a strategic partnership. As all of you know that the health sector plays a key role for us to be able to achieve justice. And if they don't do their role in the aspect of documentation, and also to be available as expert opinion, to provide expert opinion, then most of the cases will not be able to achieve their rights. On the other hand, I want to applaud the honorable justices, because definitely some of the rulings you make are in the interest of the people. You all remember the ruling on the aspect of maternal death, which required the Ministry of Health to provide a maternal and perinatal death review every year, which actually we have obliged. But if you looked at the demographic health survey, which has just been released, you see that the maternal mortality has dropped from 338 to about 189. So we're working definitely to achieve 70 by 2030. So that's also one of the aspects which we are. So the other aspect, as I conclude, the ministry definitely has put in patient charter, which definitely elucidates the patient's rights. And I would like to just implore the young lawyers, as they definitely they need to be able to look at that, because it looks at the aspect of right to medical care, prohibition of discrimination, participation in decision making, a proper medical care, and also when you can be able to, the right to refuse treatment, and all the informed consent. So in the interest of time, allow me to stop here and once again thank the organizers of this competition. Thank you very much.
We appreciate you, Dr. Lar, and Ms. Chiange for the brief remarks and opening of the session. I will not waste a lot of time, but I'll just update our honorable judges for the day that we had 11 universities by yesterday, and out of a whole day's session, we got 2 universities that are mooting before you today. So this is the final round of the moot, and I'm not sure which teams are mooting. It's CLM, which one? CLM D and E. And I, CLMD and CLMI. The reason we don't say the names of the universities at the moment is for not biasing ourselves. We also don't know which these universities are, but we know that the coding came out as that. So I will hand over to the clerk to manage the next session together with the judges, and then request all of us to just remain silent and follow the proceedings of court. We wish you all the best. Thank you.
The Honorable Chief Justice and Justices of the Supreme Court of the Federal Republic of Msiche, all men or persons who stand bound by recognizance or who may otherwise have business before this Honorable Court may now appear and they shall be heard. In the case, Supreme Court Civil Appeal number 1 of 2023, Miss Awilo Willow, the Consortium of Head Teachers of Msiche Elite Schools, Home of the Brave Shelter, and 4 others, versus Attorney General of the Republic of Msiche.
May it please this Honorable Court. Your Lordships, my name is Tumwesige J, and I'm the Attorney General of the Federal Republic of Msiche, representing the respondent appearing in this matter with my co-counsel, Mr. Herbert Chigozi, attached to my chambers. Your Lordships, the appellants in this case are represented by the Senior Land Counsel, Sunday Sharif, together with Gloria Nasije. Your Lordships, if I am of no further indulgence, we are ready to proceed.
Okay, before you proceed, you are aware about how much time you have each side, you appraised, and who is keeping the time? Okay, great. Please, you may proceed.
Yes, the court also needs to know the time assigned to each, so that 30 minutes per group. And then if one wants to respond, okay.
Proceed.
Much obliged, my lord. For purposes of court record, my name is Sunday Sharif, appearing on behalf of the respondents with my co-counsel, Nasije Gloria. We've been allocated 30 minutes of this Honorable Court's time.
Just to be clear, you are appearing for who?
On behalf of the respondents.
Okay. Our note says something different.
Much obliged, my lord.
Relax, relax, relax.
Yes, my lord. Yes, my lord.
So can you introduce yourself again?
Much obliged, my lord. My name is Sunday Sharif, appearing on behalf of the appellants with my co-counsel, Nasije Gloria. We've been allocated 30 minutes of this Honorable Court's time. I will use 12 minutes to submit on the first ground of appeal. My co-counsel will use 18 minutes to submit on the second and third grounds of appeal while making our prayers. My lords, with your permission, I'll proceed with my submission. In a world where human rights are fundamental to everyone, the principles of these human rights are enshrined both under the Constitution and international human rights instruments. It's on that matter, therefore, that we present this case to reaffirm these principles that lie at the heart of our shared humanity. My lords, it's the appellant's submission that this court has jurisdiction to hear this matter. Pursuant to Article 132, Clause 1 of the Constitution, it states that the Supreme Court is the final court of appeal. Furthermore, my lords, Section 4 of the Judicial Act states that an appeal shall lie to the Supreme Court from such decisions of the Court of Appeal. We present this matter pursuant to Section 6, Subsection 1 of the Judicial Act, which states that the appeals to the Supreme Court. The Supreme Court shall confirm, vary, or reverse judgments by the High Court or the Court of Appeal. It's the appellant's submission, therefore, that this court should reverse the decision of the Court of Appeal, because the appeals court erred in law, where the court held that it could not make a decision on sexual and reproductive health rights because the policy was pending before the court. The appeals court furthermore held that the appeals court furthermore erred in law when it absolved the state to its responsibility to provide information to girls and young women on the basis of scarcity of resources. And lastly, my lords, the appeals court also erred when told that the failure of the state to investigate and prosecute the perpetrators of sexual reproductive health rights was not an infringement or a violation on the rights guaranteed under the Constitution. We are therefore before this court. So this court can reverse the decision of the Court of Appeal. My lords, the Second Court of Appeal is not bound to reevaluate evidence or record unless it is established that the first appellate court did not reevaluate the evidence. And this was reaffirmed in the case of Arid Sam versus Uganda, Criminal Appeal number 2 of 2005. It's therefore the appellant's submission that this court has jurisdiction to hear this matter. My lords, I would therefore like to proceed with my submissions under the first ground of appeal. Much obliged, my lords. The Court of Appeal, my lords, erred in law when it held that the courts could not make a decision on sexual and reproductive health rights on a policy that was pending before the court. Pursuant to Article 79, Clause 2 of the Constitution, the Congress is mandated to pass policies for the peace, order, development, and good governance of the Republic of Nsichi. My lords, the state has not passed a policy on sexual reproductive health rights. It is the appellant's submission that this court can make an order requiring the Congress to pass a policy in regard to sexuality reproductive health rights. In the case of Amama Mbabazi versus Yoweri Kaguta Museveni and two others, in the presidential petition number 1 of 2016, the court made orders for the amendment or for the adjustment of the time for filing and determining an electoral petition, and also made an order for the adjustment of the time for holding fresh elections. My lord, all these adjustments were made in the Constitutional Amendment Act of 2018, Act 1 of 2018. This shows that indeed the court can make an order or can direct the Congress to actually pass a policy on sexuality reproductive health rights because the Congress is mandated to do so. Even under Article 14, Clause 2 of the Protocol on the African Charter on Human and People's Rights on the Rights of Women, which the Republic of Insiche is a member of, as provided under paragraph 4 of the Record of Memorandum. It requires states to undertake legal and policy measures to ensure the progressive realization of the right to health, which includes women's rights to sexuality and reproductive health rights. This means that the state is obliged to pass a policy on these rights. My lords, the state has not done so. And it is therefore the appellant submission that this court should make an order for the Congress to pass a policy, even when the respondent submits that this would be in violation of the separation of powers doctrine. It's the appellant submission, my lords, that the separation of power doctrine provides for checks and balances. And the separation of power doctrine cannot be absolute, cannot exist in real sense without the checks and balances, as held in the case of Sehad versus Attorney General Constitution Appeal number 1 of 2013, whereby it was stated that the separation of power doctrine cannot exist absolutely without checks and balances. My lords, in the 1995 Constitution of the Republic of Insiche, these checks and balances are provided for. Under Article 118 of the Constitution of the Republic of Insiche, the Parliament can move a motion or a resolution for the censure of a minister. But we also know that under Article 113, Clause 1 of the Constitution, the cabinet ministers are appointed by the President. But on the other hand, because of the validity of the checks and balances, the Parliament can still move a motion for the censure of this minister. This already shows that there is an existence of checks and balances. Furthermore, my lords, under Article 142, Clause 1 of the Constitution, the appointment of judicial officers is done by the President. However, the President is advised by the Judicial Service Commission and with approval of Parliament. This shows that indeed there are checks and balances. And in the matter at hand, your lords, it is the appellant's prayer that the same checks and balances be evolved on the matter for the Congress to pass a policy on sexuality reproductive health rights. Also, under Article 91 of the Constitution of the Republic of Insiche, the Parliament makes laws. But these laws, through bills, are assented to by the President. This means that the legislature works hand in hand with the executive for the good governance and development of the Republic of Insiche. It is therefore the appellant submission that for the good governance and development of the Republic of Insiche, this court should also exercise the checks and balances for the policy on reproductive health rights to be passed. I would like to persuade this court with an article by Mugabe, Tithembo, and Kola Odeko, where in his article entitled Separation of Power, Checks and Balances, he stated that the main objective of checks and balances is to protect liberty from tyranny. In the case at hand, my lords, it is the appellant submission that for this, the main objective of checks and balances is not to intervene in matters of any of the arms of government, but the main objective is to actually protect liberty from tyranny. I would also like to persuade this court with the case of SP Gupta versus the President of India in their 1982 CRC 365 at paragraph 330, whereby the court held that coupling separation of powers with a system of checks and balances is key to a viable democracy. This is also key to a viable democracy for the Republic of Insiche. And that is why the appellant submits that indeed the Court of Appeal erred in law when told that the court cannot make a decision on the policy that is pending before the Congress. Yet, my lords, in the case of Amama Mbabazi versus Yoweri Kaguta Museveni, already the court made recommendations, which these recommendations were followed. And it is therefore our submission that indeed the Court of Appeal erred in law when it held that it cannot make a decision on a policy that is lying before the Congress. With that, I so beg to submit and call upon my co-counsel to submit on the second and third ground, on the second and third grounds of appeal. I so beg to submit.
May it please this honorable court, my name is Nasija Gloria, as earlier introduced by my co-counsel, appearing on behalf of the appellants, and I'll be addressing ground 2 and ground 3. With the permission of this honorable court, I'd like to proceed and address ground 2, that the appeals court erred in law when it absolved the state of its responsibility to provide information to girls, young women, vulnerable groups, and institutions on the basis of scarcity of resources. My lords, Article 41 of the Constitution of the Federal Republic of Nsiki provides for the right to access to information. And furthermore, Article 10, paragraph H of the Convention on the Elimination of All Forms of Discrimination Against Women provides that state parties shall take all appropriate measures to provide access to specific educational information to help ensure the health and well-being of families, including information and advice of family planning. And also, Article 14, Clause 2, Paragraph A of the Protocol to the African Charter on the rights, African Charter on Human and People's Rights on the rights of women in Africa. It is provided therein that state parties shall take all appropriate measures to provide adequate, affordable, and accessible health services programs to women, especially those in rural areas. My lords, the appellants are alive to the fact that these rights are progressively realized. According to Article 2, Clause 1 of the International Covenant on Economic, Social, and Cultural Rights, it provides that states shall undertake all measures individually or through international assistance or cooperation to progressively realize these rights of economic, social, and cultural rights. And the immediate thing that is to be done is adoption of legislative measures. My lords, progressive realization is defined under General Comment number 3 on the nature of state parties' obligation as a recognition to the fact that the full realization of these economic, social, and cultural rights will generally not be achieved in a short time. And furthermore, General Comment provides that states are to take concrete and targeted measures to achieve these rights under the Covenant. And this was also held in the case of Prohit and Muro versus the Gambia. And what amounts to concrete and targeted measures? This was defined in General Comment 1 on the reporting by state parties by the Committee on Economic, Social, and Cultural Rights as those which states do, aiming at fulfilling the rights under the Covenant, which requires the adoption of a detailed plan of action that elaborates carefully targeted policies and priorities, my lord. In order for economic, social, and cultural rights to be realized, there are 3 things that ought to be fulfilled. The first one is adoption of legislative measures. It is the submission of the appellants that the state failed on its obligation to pass legislative measures that provide access to information to the young girls, young women, vulnerable groups, and institutions in the Federal Republic of Nsike. The second is to individually realize the rights recognized under the Convention. In any event, the respondents submit that the state was a developing country and it also has it has GDP of 4% per annum. Indeed, the appellants acknowledge. However, according to the African Commission on Human and People's Rights, in its principles and guidelines on the implementation of economic, social, and cultural rights, it is provided therein that where states need sufficient resources to progressively realize economic, social, and cultural rights, there are a variety of means through which states may raise these resources, including taxation. And this taxation is also further provided under the African Charter, Article 29, Clause 3, which provides that individuals shall have a duty to pay taxes imposed by law in the interest of the society. Therefore, the respondent cannot rely on the fact that they had scarcity of resources in order to individually realize the economic, social, and cultural rights. And moving to the third limb of my argument is that through international assistance or cooperations. According to the Maastricht Principles under paragraph 34, it provides that a state has an obligation to seek international aid or assistance in order to realize these economic, social, and cultural rights. And it is the appellant submissions that the respondents did not seek international aid or cooperation in order to realize these economic, social, and cultural rights. Hence, it is the submission of the appellant that the appeals court erred in law when it absolved the state of its responsibility to provide information to the girls, young women, vulnerable groups, and institutions on the basis of scarcity of resources.
The principles, Maastricht principles, how do they rank? How much weight should the court attach to them when making a decision?
Much obliged, my lord. I would like to persuade this honorable court with the Maastricht principles. With the permission of this honorable court, I'd like to proceed and address ground 3. That the appeals court erred in law when it held that the failure of the state to investigate and prosecute the violators of sexual and reproductive health and rights of the girls, young women, vulnerable groups, and institutions, and the girls' rights guaranteed under the Constitution. My lords, it is the submission of the appellants that everyone has a right to the protection by the law, and this is provided for under Article 21, Clause 1 of the Constitution of the Federal Republic of Nsike. Subsequently, under Article 4, Clause 2, Paragraph E of the Maputo Protocol, it is provided therein that states have a duty to punish and prosecute violators of violence against women. And in the case of equality, now an Ethiopian Women Lawyers Association versus the Federal Republic of Egypt, that was before the African Commission on Human and People's Rights and was decided in 2007, the committee noted that the state has the duty to investigate the violations of human rights that happen within its jurisdiction. Additionally, in the case of Velasquez Rodriguez, that was before the Inter-American Commission, that was before the Inter-American Court of Human Rights, the committee noted that states are obligated to investigate and prosecute the violators of violence against women, my lords. And in order to comply with this, a state has to investigate and prosecute the violators of violence against women. And if the state fails to prosecute or investigate, then it has failed on its obligation to prosecute and investigate on the violation of the violators against women. Furthermore, my lord, in the case of Egyptian Initiative for Personal Rights versus Egypt, that was before the African Commission on Human and People's Rights, that was decided in 2011, under paragraph 163, the Commission found that the failure to investigate towards an effective outcome and the state relies on and the excuses of the state are buttressed on lack of information, that shows the lack of commitment to provide an appropriate remedy. And the lack of commitment was also further elaborated in the case of Maria de Pena and Maria Fernandez versus Brazil. That was before the Inter-American Commission under paragraph 57. The committee noted that ineffective judicial action, impunity, and the inability of the victims to obtain compensation is an example of lack of commitment by the state to get an appropriate action. And my lords, the UN Committee on Human Rights has shown that complaints must be investigated promptly so as to get an effective remedy for the victims. And the respondents are obligated under Article 4, Clause 2, Paragraph F of the Maputo Protocol to provide measures that are used for rehabilitation for victims of violence against women, and this is also provided for under Article 4, Paragraph 2, under Article 4, Clause 2, Paragraph E of the Maputo Protocol, where in addition to the state's obligation to punish and prosecute violators of violence against women, it goes ahead and says these states also have a duty to establish rehabilitation places for victims of violence against women. Hence, the appeals court erred in law when it held that the failure of the state to investigate and prosecute violators of sexual and reproductive health of the girls guaranteed under the Constitution. With the permission of this honorable court, I would like to proceed and make the prayers of the appellants. My lords, we pray that the Supreme Court reverses the decision of the Court of Appeal and finds that 1, the state failed to pass a policy on sexual and reproductive health and rights of the girls, young women, vulnerable groups, and institutions. And secondly, the court directs the state through structural interdicts to pass a policy on sexual and reproductive health rights of the girls, young women, vulnerable groups, and institutions. And thirdly, the court finds that the state failed to provide information to the girls, young women, vulnerable groups, and the institutions. And also, the court finds that the state failed to investigate, prosecute the violators of sexual and reproductive health of the girls, young women, vulnerable groups. And lastly, we pray that this court awards costs and damages to the appellants and awards general damages to the victims and also punitive damages, and orders the respondent to pay rehabilitation costs for the victims, and orders the respondent to give a public apology, relying on the Human Rights Enforcement Act. With the permission of this honorable court, I so beg to submit.
Before you take leave, I will see if their lordships have any questions to you, matters that they need to clarify before handover.
Much obliged, my lord.
I want you to reconcile progressive realization of human rights vis-a-vis the scarcity of resources. I thought the scarcity of resources influences progressive realization.
Much obliged, my lord.
No, because I want you to reconcile the two, respond to that.
Yes. In response to your question, my lord, in reconciling between progressive realization and scarcity of resources, the African Commission on Human and People's Rights, in its principles and guidelines, provided therein that where states are not able to provide this, to progressively realize economic, social, and cultural rights, can get these resources through taxation. And also, under Article 2, Clause 1 of the International Covenant on Economic, Social, and Cultural Rights, it provides that states are to progressively realize economic, social, and cultural rights with the availability of its resources. However, where there is this inadequate resources, then it has to seek financial assistance or cooperation in order to fully realize economic, social, and cultural rights.
Any more comments from El? Okay, thank you. You can take your seat.
Your Lordships, may it please this Honorable Court, for purposes of court record, my name is Tumwesige J, and I am the Attorney General of the Federal Republic of Insiche in this matter. Your Lordships, I will first concur with the appellants in this matter in respect of jurisdiction of this Honorable Court. And as a matter of law, Your Lordships, I do not intend to waste this court's honorable time in reiterating myself on jurisdiction. Your Lordships, I would like to first and foremost delve into ground one of appeal as the appellants in this matter contest. Ground one of appeal, Your Lordships, is to the effect that the Court of Appeal erred in law and fact when it held that the court could not make a decision on a sexual and reproductive health and rights policy that was pending before the Congress. Your Lordships, I would like to first and foremost note the aspect of time. We've been allocated 30 minutes of this Honorable Court's time. I intend to use 20 minutes of this Honorable Court's time, and my co-counsel will use 10 minutes of this Honorable Court's time. Your Lordships, I would like first and foremost to bring to the attention of this Honorable Court that in as far as the decision of the Court of Appeal is concerned, that decision is that which was married with the principles of constitutionalism that were propounded by the great philosopher Montesquieu in his early days of 1748 in his book Spirit of Laws. Your Lordships, the principles of constitutionalism that I'm referring to entail: 1, the doctrine of non-interference; 2, the doctrine of non-duplication; 3, the doctrine of independence. Your Lordships, it is the respondent's submission that all these 3 principles, as they were propounded by Montesquieu in his masterpiece, Spirit of Laws, have been reiterated in a number of your decisions, Your Lordships. The principle of the doctrine of non-interference gave birth to the doctrine of separation of powers. And as a result, Your Lordships, the principle of the political question doctrine arises under those circumstances. I would like to first define what amounts to political question doctrine as it is provided for under Black's Law Dictionary, 9th edition by E. Garner at page 1277. Your Lordships, it is the petitioner's humble submission, it is the respondent's humble submission that the learned author of Black's Law Dictionary at that page defines the political question doctrine as a judicial principle that a court should refuse to decide an issue involving the exercise of discretionary powers by the executive or legislative branch of government. Whereas, Your Lordships, that amounts to the definition of a political question doctrine. A political question is further defined by the same author in the same page as a question that court would not consider because it involves the exercise of discretionary powers by the executive or legislative branch of government, also termed as the non-justiciable question. It is upon that background, Your Lordships, that I delve into the nitty-gritties of ground one. Your Lordships, Halsbury Laws of England, at 4th edition, at page 1989, paragraph 5, also concurs with Black's Law Dictionary in reference to the political question doctrine and a political question. Your Lordships, it is a settled principle of law that the principles of constitutionalism should be given much attention in as far as human rights are concerned. And Your Lordships, I would like to rely on the Court of Appeal decision, while bearing in mind that it is not binding before Your Lordships, but it is that which is persuasive in nature. The decision of Ibrahim Damulira versus Attorney General, miscellaneous application number 24 of 2015, arising from miscellaneous application 23 of 2015, and itself arising from constitutional petition number 27 of 2015, while citing with approval the decision of the Court of Appeal in Miriam Matembe and two others versus Attorney General, constitutional petition number 2 of 2005, it was held that it's clear to us that in the first limbs of Article 137, Clause 3, Paragraph A, the Constitution provides for the challenging by any person who satisfies the relevant parts of the rest of Article 137, the constitutionality of an Act of Parliament and not a mere draft's proposal for an Act of Parliament. If the framers of the Constitution intended it that the constitutionality of a bill for an Act of Parliament can be challenged, they would have explicitly stated so. Your Lordships, while seated here listening to the appellants' submissions, I realized that the appellants here are challenging a sexual and reproductive health policy. That is a policy, Your Lordships. It is not yet a bill. It is not yet an Act of Parliament. It is a mere draft proposal that is before the Congress in as far as paragraph 6 of our instant facts relate. The Senate, under the Federal Republic of Insiche, is that which is conferred upon powers by the Constitution of the Federal Republic of Insiche to debate policies, and thereafter bills come into place, then the President of the Federal Republic of Insiche assents to the same, and as a result, it now turns into an Act of Parliament, which is supposed to be challenged. Your Lordships, I would like to intimate before Your Lordships that in as far as ground one of appeal of the appellant submissions is concerned, it is that which is misconceived, frivolous and vexatious. And as a result, I would like to pray before Your Lordships that may you be persuaded by the Court of Appeal decision of Ibrahim Damulira to dismiss the appellant's submissions in as far as ground one of appeal is concerned. And your lordships, it is my humble prayer that may that ground not see light before this honorable court. I so pray, your lordships. I would delve into ground 3, your lordships, of the appellant's submissions. The appellants before you, your lordships, submitted that the Court of Appeal erred in law when it held that the failure of the state to investigate and prosecute the violators of sexual and reproductive health and rights of the girls wasn't a violation of the girls' rights provided under the Constitution of Insiche. Your lordships, at the end of the day, you will agree with me that indeed the Court of Appeal never erred in law to hold the way it did. I would like to bring to your attention, your lordships, that under the ground that I'm handling is a ground that relates to the rights of juveniles, as it is buttressed under our facts, particularly under paragraph 16 of our facts. Your lordships, the appellant's contestation here under this ground is the rights that relates to the prosecution of juveniles. And from our paragraph 16 of the instant facts, it is categorically clear that the violators are juveniles. I would like to submit before you that Section 89 of the Children's Act, Cap 59, Laws of the Federal Republic of Insiche, provides for the procedure of how administration of justice relating to juveniles is supposed to be handled. Your lordships, it is the respondent's submission that in reference to violations relating to juveniles, it is a matter that is supposed to be handled with care. Because these rights, your lordships, are those that are handled like an egg. When we miss and they break, the Attorney General may appear before your lordships again, relating to matters of violations of the rights of juveniles. And your lordships, I would like to bring it to your attention that under paragraph 6 of our instant facts, the Federal Republic of Insiche is a party to a number of international instruments, one of them being the Beijing Rules, or what we normally refer to as the standard and minimum administration of justice of juveniles. Your lordships, it is the respondent's submission that under Rule 2 of the Beijing Rules, a juvenile, Rule 2, Subrule 1, a juvenile is defined as a child or younger person under the respective legal systems who may be dealt with for an offense in a manner which is different from an adult. Your lordships, these rules have enthusiastically sounded in my soul that while handling matters relating to juveniles, a juvenile's matter should be handled differently from matters of an adult. And your lordships, this honorable court has always reiterated those principles in a number of decisions, which I wouldn't like to delve into because time is not my best ally. But your lordships, the same is buttressed under Section 3 of the Children's Act, which provides for the welfare principle. The courts of judicature of the Federal Republic of Insiche have always reiterated the welfare principle in as far as juveniles are concerned. And it is to my dismay that the appellants never addressed their minds to that. Your lordships, since the Federal Republic of Insiche is a party to these international instruments, one of them being the Beijing Rules, which stipulate how the administration of justice of juveniles should be handled, and they are not my words, but they are the laws that have been stipulated under the Beijing rules, that the administration of justice of juveniles should be that which is different from an adult. Your Lordships, I would like this Honorable Court to be persuaded by Rule 2, Sub-Rule 1 of the Beijing rules, and come to the conclusion that the Court of Appeal never erred in law when it held that the violations that were conducted by these juveniles and subsequent prosecution should be given time that is reasonable. Your Lordship, I would also like to draw your attention to Rule 6 of the Beijing rules. Rule 6 of the Beijing rules, Your Lordships, confers upon the state parties to these rules discretionary powers on how and when to prosecute these juveniles. Your Lordships, it is the respondent's submission that in as far as these discretionary powers are concerned, they have been conferred upon the state parties to these rules. In situ, being a state party to these rules, Your Lordships, and as the Attorney General, I'm submitting that these rules, they confer upon the state discretionary powers to choose when and how to handle investigations, when to prosecute. And Your Lordships, it is my humble submission that in as far as Rule 6 is concerned, I believe that when we are looking at a case that, that relates to a juvenile, time, prompt investigations should be conducted. But utmostly, Your Lordships, time within which to bring this juvenile to justice should also be given notice. But again, it is important to note, Your Lordships, under Rule 6.
Counsel,
yes, please.
what force of law do the Beijing rules have?
Your Lordships, the Beijing rules have persuasive powers before this Honorable Court. And in my conclusion, I will pray that may this court be persuaded to rely on the same rules, Your Lordships. I was still submitting, Your Lordships, on Rule 6. In as far as it is provided, Sub-Rule 2 provides that the efforts shall be made, however, to ensure sufficient accountability at all stages and levels in the exercise of any such discretion. And Your Lordships, from the facts, these facts reveal that what the state of Insiche is doing is conducting investigations into the matter. The Federal Republic of Insiche is alive to a key tenet of the right to a fair hearing under Article 28, which is the presumption of innocence, Your Lordships. The appellants are relying on mere allegations that have not been substantiated. These are mere allegations, and it is a cardinal rule of our jurisprudence that courts are not bound by allegations, but rather material evidence. It is my submission as the Attorney General of the Federal Republic of Insiche that in as far as ground 3 rather, of the appellant's submissions is concerned, should not see light before this Honorable Court. And as a result, it should be as well dismissed. Whereas I would pray before this Honorable Court that may it find that the Court of Appeal rightly held as it did. And Your Lordships, it is my humble prayer that may you uphold the decision of the Court of Appeal. I so pray, Your Lordships. And your lordships, if I am of no further indulgence, I will call upon my co-counsel from my chambers to handle ground 2 of appeal. Mr. Chigozi.
Most obliged. My lords, for record purposes, Chigozi Herbert, the Deputy Attorney General, appearing for the respondent, I'm going to be submitting on ground 2 of this appeal. My lords, ground 2 is the effect that the Court of Appeal, erred in law, when to absolve the state of its responsibility to provide essential training and information to young women and vulnerable groups and institutions on the basis of scarcity of resources. It is the respondent's submission that the justices of Court of Appeal, in their wise thinking, they are right in abiding that way. The justices of Court of Appeal, we are alive to the principle of progressive resource realization. My lords, the principle of progressive resource realization is provided for under Section 13 of the Human Rights Enforcement Act 2019, and the same is buttressed under Article 2, Clause 1 of the International Covenant on Economic, Social, and Cultural Rights. My lords, this principle is to the effect that states must take all reasonable measures to ensure that progressive development in all sectors, including that of human rights, is achieved basing on the availability of the resources. My lords, as it has been submitted by the appellants, it is true, we do concede that this principle enjoins the state to ensure that within the limited available resources, all rights are observed and protected. However, my lords, there is a yardstick that was provided by the Committee on Economic, Social, and Cultural Rights in their General Committee number 3. And this yardstick is for the state to show that in case we are talking about progressive realization of rights, the state must show what it has done and what it is about to do. And this is what we refer to as the deliberate steps in making sure that rights are progressively realized. My lords, in the same general comment, the committee was emphatic when it stated that at any level of resources that are available, what the state is mandated to do is to make sure that it ensures that the basic human rights, which are social or economic, are achieved. My lord, the yardstick that is provided by the Committee on Economic, Social, and Cultural Rights was buttressed in the Kenyan case, my lords, well knowing that this case is not binding on you, my lords. However, it's a persuasive decision from the Kenyan jurisprudence in the case of Matthew Okwanda versus Minister of Health and Medical Services, which was decided in 2013. My lords, the court, in deciding a matter in which the petitioner intended to enforce his right of obtaining special treatment, which was different from that was being provided by the state. The court held that the state had properly demonstrated what it had done, that was providing the medical services, because in that case, the petitioner was clear that he had been receiving medication from the Kenyatta Hospital, and that was the court's decision that by providing the medical services that
the petition was receiving, the state of Kenya had done the bare minimum as it is required to do under the principle of progressive resource realization. My Lord, in the current state of affairs that you are handling, my Lord, in the matter before you, Article 34.2 of the Constitution of the Federal State of Insiche mandates the state to provide basic education. And the state of Insiche is alive to the fact that indeed the training on sexual and reproductive health is pertinent to the lives of the young people of Insiche. And my Lord, by that mandate that is given to the state under Article 34.2, it has established schools, not to mention but a few, Champion Ngudo High School and Jovoka Junior School. My Lord, in the curriculum that is manned by the Minister for Education, in the primary section, the pupils get to learn about their sexuality in science. My Lord, in particular, there is a science subject where there's a topic where they teach about sexual reproductive system. They are taught about the menstrual cycle. My Lord, by the provisions of Section 4, 1C of the Children Act, that gives a right to the child to receive that information that is critical to the well-being of the child. My Lord, the state of Insiche thought it wise to include the topic on sexual and reproductive health under the science subject. Further, my Lord, in the education system of Insiche, in the secondary education, which is throughout the country, like at Champion Ngudo High School, as it is now facts, students learn, they have biology subject through which they learn about the reproductive health, my Lord. First and foremost, my Lord, the essence, the main aim of reproductive health as provided for under the International Technical Guidelines on Sexuality Education is to make sure that the young children are equipped with the information about their sexuality in order to make informed decisions. And my lords, from the available avenues, through the science subject and biology, the young children of Insiche are getting the necessary information they need about their sexuality. And therefore, given the meager resources that are available to the state, it has been already submitted by the appellants that the state of Insiche has a GDP of 4%. My lords, almost 58% of the citizens of Insiche live abject abject poverty. And it is the responsibility of the state to make sure that it puts in place all avenues to cover all the needs of the people of Insiche. And how can this be done is through making sure that they adopt and adhere to the principle of progressive resocialization. My Lord, furthermore, my lords, furthermore, the principle of progressive resocialization gives us the good faith principle. My lords, this principle is to effect that while allocating resources or while doing certain acts, you should be mindful of the rights and entitlements of other people. My lord, the federal state of Insiche cannot get funds to start funding a separate comprehensive sexuality education training, yet there are other needs of the society in general that needs to be addressed, my lords. This very principle was upheld in the case of MOOT Bell Welfare Society versus Attorney General and 2 others. Still, my lords, it's a Kenyan case, and I pray that you're persuaded by this case. My lord, in the further jurisprudence of South Africa, in the case of Sabromani versus Minister of Health, my lords, the court was emphatic when it declared that the request of the petitioner to receive specialized medical treatment was out, over and above what was put in the budget for health of South Africa. And to that effect, the court applied the principle of progressive socialization and denied to grant the prayers of the petitioner.
Can you say that again? What was the decision?
My lords, in that case, basing on the principle of progressive socialization, the court found it wise to hold that, given the small budget that the Minister of Health had, at that moment, responding to the emergency of Mr. Sabromani would constrain or would stretch the small budget that had been allocated to the Minister of Health. And therefore, if the Minister of Health or that the hospital was to go ahead and make the operation on Mr. Sabromani, then that would amount to sabotaging other activities that would be that the Minister of Health was mandated to do. That would be against the principle, the good faith principle, my lords.
And so, what was the decision?
That
seems to be halfway.
My lord, the decision was the petition was dismissed because the court could not hold the state accountable for not providing the specialized amputation of the leg for Mr. Sabromani, because it would constrain the state's budget. My lord, I pray for 1 minute to sum up. Most obliged, my lords. My lords, it is therefore the applicant, the respondent submission that this court, through its powers that is vested to it under Rule 31 of the Judicature Supreme Court rules, that it upholds and confirms the decision of the Supreme Court. Oh, most obliged, my lord, that this court uses its powers conferred to it by Rule 31 to confirm the wise decision of the Court of Appeal, my lords. We so pray, my lord.
Any questions, my lords?
Yes, the Attorney General, you are very spirited about protecting the rights of the juvenile. Stand up, please, as we speak to you. You are very spirited about protecting the rights of the juveniles.
Yes, my lord.
And that they should be given time before they can be prosecuted. You quoted a lot of law on children. Now remember, these victims were all equally juveniles.
Yes.
So how do you balance that? And by virtue of your age, are you protected from prosecution, really? Is that the law?
Not really.
Can you know, clean up that a bit or clarify?
Your lordships, I would like to submit before you that in response to the question you've given to me, I am unable to cite a very particular law relating to the Beijing rules, but under these Beijing rules, there is a principle of proportionality that yes, the juveniles have committed an offense, but when now court sits to decide on that matter, it should be alive to the proportionality principle. And these Beijing rules stipulate that the proportionality principle entails, one, the nature of the offense that the child has committed or the juvenile has committed, and with reference to the age and the consciousness of the child. And as a result, it is the respondent submission that, Your Lordships, I'm not calling upon this Honorable Court to cast in doubt the rights of the girls that have been violated, because there are also rights that must be protected. But may this court be persuaded and guided by the principle of proportionality. I so pray, Your Lordships.
My question is also to the Attorney General in relation to the very same thing, to the Beijing rules that you cited, but also to the welfare principle. When you spoke about, and you even in fact said that you were surprised that the appellants did not address their minds to the paramountcy of the welfare principle and the importance of treating those matters that relate to children in general with expedience. Were you arguing for the respondent? You were the Attorney General.
Yes.
Yes. Were you arguing for the respondent when you said that these matters must come to court quickly and be treated with urgency? What did you mean by that when you said you were surprised that they did not address their minds to it?
Your Lordship, in what I was referring to is that we concede that from these instant facts, there seems to be a delay of the prosecution, the handling of the file, and each and everything that relates to the case relating to juveniles. But however, when I was referring to the immediacy and paramountcy of these rights, is that it has been the court's finding that the welfare principle should always be upheld with Your Lordships. And as a matter of fact, I would like to intimate before you that as the Attorney General, like we considered in these facts, we are doing whatever possible to ensure that we get the evidence that is required and we handle this juvenile's case as reasonability of time is concerned. Your Lordship, I would so submit.
Just to the Deputy Attorney General. Thank you very much. You spoke about the biology classes that they're being conducted in the schools and what you're teaching on reproductive health, what you've incorporated in those biology classes. If those classes are being conducted, then why is there a high incidence of girls engaging in unprotected sex? Has the state looked into that? But also, just to let us know what steps you have taken on in protecting the girls and educating the state on sexual and health, reproductive health. The steps that you have taken besides teaching in the biology classroom.
Most obliged, my Lord. My Lord, about the steps that are being taken, there is a bill that is before Congress, and among the provisions of the bill that the State of Institute is working on is the provision that relates to the provision of sexuality education training to the young people of Insiche. And once the bill turns into an act, then we have a proper framework that is going to guide the sexuality education training.
So what you're saying, the state is only prepared to offer protection for girls through training only? Training in schools only? That's what your policy is?
My Lord, as I was submitting, I was clear that among the provisions that we are intending to put in the act, or among the proposals in the bill, one of them is provision of training. And apart from training, we are also going to put in place measures that will ensure that even though the girls receive the training, there should be enough funds and resources to take care of the girls' victims, just in case there is any violation on their sexual and reproductive health rights.
Thank you very much, Attorney General. In your submissions, if I understood you very well, you seem to be of the position that while the juvenile offenders should be investigated, time should be taken before they are prosecuted. You run a danger of having them crossing from the line of being juvenile to adults by the time you go to prosecute them because of delayed action. That's number one. Number two, according to the mischiefs that seem to be reflected in the Republic of Nsiche, the policy that the appellants seem to be pursuing is a policy that actually is holistic. It's not necessarily for punishing the offending juveniles against the juvenile girls, but actually it should also take care of the juvenile boys. That seems to be a missing link. The sexual-related offenses, as a result of absence of the policy that the petitioner seems to, or the appellant seems to be pursuing for, is to cure the conditions that seem to be prevailing that are leading to massive sexual offenses against juvenile girls, but some are committed by the juvenile boys. What's your comment?
Much obliged, Your Lordship. And, excuse me, excuse me, Your Lordship. I would like to first handle the first limb of your question that related to the time frame within which these cases must be handled. And Your Lordship, your concern is in relating to the time frame that the juvenile might have crossed from the juvenile stage to an adult stage. But Your Lordship, it is a cardinal rule of our jurisprudence that when we are handling these cases, we refer back to the time when the offense was committed. And I believe that when we are prosecuting these juveniles, the file must mention the time.
Just a minute. The age at which the offense was committed is what is absolutely relevant in deciding which procedures you adopt. So if the fellow, for example, committed the offense when he was 15, he's being tried when he's 20. He's tried as an adult. The procedures change, not so. What perhaps will be considered is when you are deciding the sentence or the sanction arising from whether he's guilty or not. That's when you consider, was he a minor? Was he a juvenile? But the trial process changes. All right? It becomes as elaborate as when you are trying a treason, or a murder, or a robbery by an adult. That's why it is pertinent that when you are dealing with the juvenile offenders of the nature that is being complained of in the Republic of Nsiche, the investigation must be very fast done. Because juveniles have a tendency to forget, because they're still minors. You remember? The procedures are supposed to be less elaborate, no? Simplified. So that's why perhaps you need to reconsider your position, you and the government of Nsiche.
Much obliged, my lord. As the Attorney General, we are surely going to consider the same, and the report will be disseminated to the stakeholders. Your Lordships, if I have of no further indulgence, I pray that much obliged, my lord.
as Attorney General, of course, you have to shield many questions, and this is our last opportunity, of course.
Much obliged.
They have another chance.
Yes.
You agreed that the Beijing rules are of persuasive value, and according to my count, your case relies about 80% on the Beijing rules. Would you be surprised if the court found that you don't have a strong case, therefore?
Much obliged, my lord. Article 44 of the Insular Republic, much as it provides for the ratification of these international instruments, we have a domestic legislation that relates to the same. And your lordships, if my head serves me right, I cited before you Section 89 of the Children's Act, Cap 59, as amended, that same provision handles the procedure relating to juvenile justice. And it is my humble submission that Section 89 is in pari materia with the Beijing rules. And as a result, your lordship, I would submit that much as the Federal Republic of Insular is relying on the international instruments, but there is also a domestic legislation or law that provides for the same. I so pray, your lordship, that may this appeal be dismissed and the Court of Appeal holding be upheld. I so pray, your lordships.
Is there a right of reply? Okay.
You have 5 minutes, remember? And 5 minutes.
Please go ahead.
But your right of reply can also be that you reiterate your earlier submission. Nothing to add.
My lord, the respondents have submitted that in order to realize economic, social, and cultural rights, the state has to show what it has put in place in order to realize these economic, social, and cultural rights. And the respondents stated that they have they are yet to put in place a legislation. However, if I may persuade this honorable court with the Limburg principles on the implementation of economic, social, and cultural rights, under paragraph 18, it is stated therein that legislation is not sufficient to fulfill the obligation of these rights provided for in the covenant. Furthermore, her lordship raised a concern that is it only the bill that the state has put in place, and the respondents misdirected this honorable court by stating that the bill provides for the young children to learn more about sexuality. However, the bill at hand provides for sexualization of minors and sexual abuse, that is in the record of memorandum paragraph 6, and the need to provide for sexuality education, it is that which Sohadi was striving for. And it proposes recommendations to the state to insert in additional clauses that provide for the learning about sexuality. However, the bill was revised twice, and these additional clauses were not added to the bill. Secondly, if I may persuade this honorable court with the case of X versus Netherlands that was before the European Court on Human Rights, and it was decided in 1985 under paragraph 32, it provides for what amounts to prompt investigations. The respondents stated that they would conduct prompt investigations, but did not provide what amounts to prompt investigations. And therein, they state that for investigations to be prompt, they must be aimed at identifying the victims and also to bring an appropriate remedy. However, under the record of memorandum, paragraph 16, it is stated that even though these teenagers who engaged in this act were known, there has been no arrests up to date. And also, my lords, the respondents stated, largely relied on the Beijing rules and stated that the appellants have failed to recognize that these are minors. But I would like to remind the respondents that the Federal Republic of Nsiki does not condone these acts of the children. That's why it has put in place a procedure for when a child is young, and it also gives the age of criminal responsibility, that is 12 years. And this is aimed at the best interest of the children. That is provided for under Article 3 of the Covenant on the Rights of the Child. And in order to realize that, why they have put in place juvenile places is such that these children can reach that place and change and become better people in society. And also, my lord, the respondents stated that they have put in place sciences. However, under paragraph 8, it is specific as to which students don't know much about anatomy. And they said a report on 85% on the students doing humanities. That is specific. And that is why Sohadi was pushing hard that these additional clauses are put into the bill such that students, whether humanities or sciences, can get to know about sexual education, and which the state failed to recognize. And when it amended its, revised its bill twice, it did not put that into consideration, my lord. And also, the respondents submitted that they have put in place, they are planning that they will educate these children. However, and it is just as a result of the scarcity and relied on the case of South Africa. But, my lords, there are minimum core obligations that ought to be fulfilled, regardless of the availability of the resources in the country. And this is provided for under the African Commission on Human and People's Rights in its principles and guidelines on the implementation of economic, social, and cultural rights, under paragraph 67, that states ought to provide education and access to information concerning the main health problems in the community, including methods of preventing and controlling them. And in this instant case, the state of Nsiki failed to fulfill its minimum core obligation to provide education to these children and the society. As we can see, a number of people in the society have suffered. Even a girl lost her life as a result. I so beg to submit, my lord.
I wanted to ask you, if I understood the Attorney General very well, he was saying that justice rushed is justice crushed. So you are saying that they should be prosecuted immediately. The Attorney General is saying, let's investigate properly. How do you reconcile that?
Much obliged, my lord. And in response to that question, that the appellants actually recognize that under Article 21 of the Constitution, everyone has a right to protection by the law. And it is in that regard that the appellants, although these victims were known, they didn't even go and conduct any fights against them, but they were waiting on the police to carry out their duty to investigate, prosecute, and punish the violators of sexual offenses as enshrined in Article 4, Clause 2, Paragraph E of the Maputo Protocol, my lord.
Then something else is on resources. I think your team was submitting on mobilization of resources outside the country of Nsiche. Is that a guarantee that they can get those resources? And then you're also talking of taxation. How do you tax the poor people of Nsiche? What was the percentage? 80% living below the poverty line. So how do you expect to get the resources for? Maybe you can answer.
But what I'm going to ask more or less touches the Attorney General, the Deputy Attorney General in particular. This will have nothing to influence the results of the competition, but it's good worth discussing because that's why we are here to educate each other. The situation pertaining in the Republic of Msiche does not seem to be a situation that is curable through classrooms teaching biology, because the population is all in danger, including the girls and little boys that don't go to school. So that calls for a policy beyond what is taught in classroom. Msiche has other children who have never heard of a word biology class, all right? So Attorney General, what do we do? Don't we need to rethink beyond this thing of saying, there is UPE, they're going to run these things in class. The problem is big. The juvenile, I'm sorry, I have to get out of now the competition, talk about something else. The child, you could sit down briefly, Lady Counsel. What is at stake is wider than just what is manageable in classrooms. Society is built on the young ones. Emite mito, is that what they call it? Unless we cure the mischief now, tomorrow we have no society. Kids that impregnated below 13 cannot be the development leaders of tomorrow. Therefore, the socioeconomic development of the country is endangered unless we start from the grassroots. I don't know what their lordship will decide. I'm not being a rebel, but I'm addressing a fact that this is a mischief. You are the leaders of tomorrow. You must think along it as you grow to decision-making level. Unless you cure the mischief right from the beginning, we don't have a future. The sexual offenders are at the grassroots. The children, girl children, get pregnant too early. We get fathers who are less than 14 years. So tell me, what society do we have tomorrow? So we need a policy, whether by taxation, source money, by any other resources. We need to educate everybody about their sexuality and the dangers involved. Some are getting pregnant. I will share with you this because I used to be a juvenile judge some time back. You would ask a kid, said, "What is this?" The kid would say, "Judge, I don't know how many will understand Uganda to help me to put it across." But he would say, "Look here, Judge, we're just trying to see how sweet it is. And this stupid girl became pregnant." You see that innocence at its lowest level? You know, that kind of thing. So that is lack of education about the danger into what you are trying. You see, Attorney General, that's why you need to do a little more than what we are talking about. You wanted to say something?
Okay, 1 minute.
Yes, my lord. I wanted to respond to the question that had been posed by his lordship. And in response to that question, whether it's obvious that these resources will be given, but under general comment number 14, it is stated therein that these states have an obligation to seek international aid. But and the state which has the resources is the state that will provide the resources.
Thank you. So this is how we are going to proceed. We are going to break. The justices will retreat to come to a conclusion, and really the organizers will be able to come back to us when they are sure you've had enough break, and then we'll come here, we'll make some comments, and then announce the decision.
Okay, well, the Justices Caucus, please note that we're already running late in terms of time, so we'll be very disciplined. We'll need to be very, very disciplined right now. And if we can just take a health break of about how many minutes? 20? Is that fair? Yeah? Because we don't want the judges to come back and find an empty room. So we're going to take a break. I don't know if tea is served. There's tea. So let's use the shortest time we can and ensure that we come back for the next final sessions when we're all put together, because it's a very serious session and we need your due attention. Is that okay? Esther, do you have some announcements?
We have some feedback forms that I'm going to give out to all participating students and coordinators. Kindly fill in the form and give it to us. Why? Because we want to get feedback. Every year we try to make ourselves better for the next MOOT, so we need to know what went well and what didn't go, so that you can be able to go back and see what we can do better. So kindly grab a cup of tea and come back here. As soon as you come back, I'm going to come and give you the forms in like 5 minutes, and then you give us this feedback. Is it okay? I hope all the universities are here and their representatives, because we need feedback from each of the 11 participating universities.
Okay, so maybe before we step out, you could just be patient and Esther distributes the forms. Pardon? Or you can pick at the entrance while you enter after the tea break. But it's very important that we receive this information or feedback to help us plan things better and bigger next year. So please stand up, please. Make the most out of your time right now. Freshen up. We're going to be intentional. We're looking at 20 minutes at a stretch of 25, but 20. Thank you.
judge, let's use phone here.
Students and coordinators, please, we need your feedback. Yeah. You don't have to put your name, just put the name of your university. Can pick. This feedback is important to help us improve next year. So if you don't give it to us, we shall assume everything is actually fine.
whenever the panel comes back, you need to read the names of the members of the quorum so that the lawyers and the parties know who is hearing their case for next time. We are going to spend a few minutes making comments because you're here to learn, and their lordships have made some observations. So we are going to allow a few minutes for them to make the comments, and then after that we'll announce the results, and the program will hand it over back to the organizers. So I'll start with her lordship, Victoria.
Thank you, my lord. I'd first want to say that I commend all the participants very much. You did very well, and I wish the Attorney General could pay attention as the court speaks to him. You all did very well. I commend the courage and the tenacity to compete to this stage. It is always difficult for somebody who's making the opening statement, the opening gambit, even in a game. But you did very well. You took courage and did well. And sometimes there was repetition from some of you on some of the points, trying to recollect some of the things. Generally, very well grounded in the principles of the law and the arguments that you were making. You presented your grounds very well, especially the person who substantiated his grounds when he was arguing on, I think it was progressive resource realization and the application of the law and what they have done as the state. That was very good. But also the eye contact, I don't want to exhaust what everybody will say, but the eye contact was good for some of the participants. Your recollection of the principles, sometimes you have to say to yourself, how do I sound? Be as natural as yourself. It takes a lot of practice. It takes courage to come before a real court. But you did very well. Those are my comments. I'll reserve the rest, leave the rest to the other members of the panel.
Yes, thank you, my lord, and thank you, everybody, especially the 4 people before us. As she says, it's not easy because there's a lot of expectations from the people who you represent, and you also need to impress us. But I think there's been a lot of improvement. I have been to many this kind of moots, and I've been to some, and I see an improvement every time. So at least you can pat yourselves on the back on that. The presentation, of course, yes, you need to improve on a few things. First of all, we gave you a lot of time. Nobody gives you 30 minutes before the courts, especially the Court of Appeal and Supreme Court. They'll probably give you most 10 or 15. So you must be very well prepared with just what you need to say. I could see eventually you had said it all, but because you had a lot of time. And that really irritates the bench. So even if you've given 20 minutes and you feel you've done it in 10, stop. I'll be impressed as long as you have said what you have to say. The facts were actually very, very long. I think this is because it's a moot. They are not that long usually in real life situations, but sometimes they are. It's very important at the beginning to relate the facts very briefly, because remember, like I said, they don't give you that much time. Or you could say, my lord, I will not repeat the facts because they're on record, but at least show me that the thrust of my submission is going to be hinged on these very facts. So none of you really was talking about the facts, and none of you were even relating to the facts as all as you argued your matters. You all have a very good grasp of the law, but every lawyer really should have a good grasp of the law. So if you want to have an edge, then you must go a little bit beyond that. You don't need to keep quoting the cases. In the case of Magnatan versus the 2 ELR, no. You will not have all the time. And remember, in real term, you are allowed to file your authorities. So the court already has your authorities. So you're probably better placed if you are wanting to use the law very well. You could cluster a few cases together, and you could just give one name of the case or maybe two, and then you just bring out the principles, because you might have so many good points, but you wasted a lot of time in giving those long quotations. And etiquette, yes, of course, since you are still students, there's a lot of etiquette in court that you probably learn as you come to courts. If I could turn to Uganda, is kajanja in the courts, but you don't have to to do a lot of posturing. Okay, just stand. I know you can sometimes be, it's because of nerves. Try and keep your nerves down, and so that you make a good presentation. Make sure your flaps, some of you can see your flaps are all over the place even now. There are some judges who are very strict, and they will tell you as soon as you walk in. I know some of us were not dressed, but because it was of short notice. But try, before you go in, ask your neighbor quickly, am I smart enough to be before the court? I saw a lot of quotations of old scholars. Some of those things we are kind of moving away from them to more simple, straightforward, simple English presentations, even when you're writing your submissions. You may quote Aristotle, and maybe I don't care too much about Greek mythology. I'm more interested in what you are saying about the questions before you. I think that is for now.
Thank you, my lords. Just question.
All right, thank you very much. These ladies have said it all. I don't see what else I should say. But I would like to comment that I saw the MOOT of last year. This one is better. But the key thing that you need to know is preparation, preparation, preparation. Read the facts of your case, get your authorities if you want, summarize those points that you would like to be said and picked. Just precise, be as precise as possible. The four of you were steady enough. But particularly I would like to commend the Deputy Attorney General. You impressed me, and somebody else should also learn from this. Not only did you argue the case according to the policy and the law, you referred to the things in the ground in that little place of Republic of Nsiche. Perhaps because I know a village called Nsiche myself. No, it exists for those who don't know. It's a notorious place, actually, where all those mischiefs you're talking about take place. It's not far from my former schools, so as a young man, I know where that place was, right? I hope it's still not there. Thank you very much, but prepare, be as natural as possible. To emphasize what the Lady Justice said, use as simple language as possible. It's not impressive to use complicated sentences, because all we are interested in is how do you deliver what you want to say, right? Don't make quotations. Yes, you can pick one or two. When you want to emphasize a principle derived from a section or the article in the statute to the application in a living or decided case. Don't go into too much details, right? Thank you very much.
I must say this was a wonderful team of presenters. I know the first presenter, of course, being the first presenter and appearing before judges. You panicked a little bit, but it's okay. All these things, you will even realize that when it comes to real practice, your first case may not be your best case. You see, there is always that panic. Eh? How do I do it? Sometimes, actually, in actual practice, you will go to court and you find the person who is the other side is Justice Kwesiga, and you are aware that he has been in court for 30 years, and then that itself will give you a challenge. But I must commend you, because you recovered very quickly, and then you presented very well. However, the Attorney General, it is always better when you are presenting, you follow the chronology of issues as presented by the appellants. Do not present one and then three, and then the other one presents two, because we always want to follow the chronology of issues. It's not a good practice. It's not illegal though, but it's not a good practice. So next time if you are presenting, make sure that you are going to present either issue number 1 and number 2, and then your colleague presents issue number 3, so that you follow the chronology of the issues. Otherwise, then we get a disorganized record. Then, of course, one of the other things you need to do is always to refer to the record. And I think the Deputy Attorney General did it at some stage, where you say, in the record of proceedings, this is to relate the record of proceedings with your arguments, to support the argument you are making. I think that's a good practice. Okay. Otherwise, I must commend you. I also must say the previous MOOT, which I presented over here, I think this is much better. That means there is improvement in terms of how you train the MOOTers and etc. Thank you so much.
Thank you very much. Yeah, let's give the PJ a hand clap. And thank you all for coming. Thank you for the MOOTers. I associate myself with their lordships that you did a very good job. Very, very good job. Let's give you a hand clap. So in addition to all that has been said, I just re-emphasize you don't have to use up all the time. When you've made your case, sit down. As just Togola told me, when you get up, stand up, speak up, and then shut up. I will go to the Beijing rules. You know, you have to know persuasive versus binding. And you cannot keep hammering persuasive, because you know that's what registered in my mind, that this case is relying so much on Beijing. In fact, I don't know whether because of that now I didn't even register that there is domestic legislation which is the equivalent. So you have to ensure that you drum up the binding. And again, the art, you had room. I would have wanted one of you to get out of the desk and come and move around, you know, be free, and that's part of relaxing. Mostly in the court it will be a straight jacket, but if you have room, please use it. But added to that, I want to thank you all. The standards were very, very, very high. We are impressed. And I would like to thank their lordships for sparing their time. These are very busy people. I know the organizers maybe will say this, but I have to say it as well. Very, very busy people, and they have spared their time to come and be with you. It's not something you take for granted. So let's thank them. And especially His Lordship, the Principal Judge, is actually on leave, but he has been able to come and spend the time with you. My Lord, we are grateful. The other thing is we've lost somebody in the legal fraternity who is a sister of a member of the court, and so many of us would have wanted to be at the funeral service. But again, we had confirmed with you, so we didn't want to portray an image of the judge has said this and then he has done this. So their lordships here decided to forego the funeral service of sister of their colleague to come, and just to let you know that a judge's time is competed for by many, many things. And thank you, my lordships, your lordships, that you've been able to come, and we do this. Now the results, and just so you know, we had score sheets, and as you saw, each was scoring independently. And then we went and surrendered our score sheets to the organizers. They are the ones who totaled and came up with the final result. So, as far as this case is concerned, very, very, very close as you would expect. The respondents scored 77.1%. Let's give them a hand clap. And the appellants scored 77.3. And so the appellants have taken the day. Congratulations. But as you can see, very, very close. It was a question of 0.0 something. Now we also had to find out who is the best oralist. You know who. We want to see if your knowledge tallies with what their lordships think. And I'm going to read them in, is it ascending or descending? It will be ascending. So respondent number 2 scored 73%. Let's give, yeah. Appellant number 1 scored 73.8. When I read you, you have to stand up and bow and say, much obliged, my lords. So, as I said, respondent number 2, 73. Appellant number 1, 73.8. And appellant number 2, 80.8. Respondent number 1, 81%. So you can see the difference between respondent 1 and appellant 2 is 0.02. It was very, very close. The best oralist, therefore, is my honor and pleasure and privilege and singular duty to announce that the best oralist for our MOOT today, respondent number 1. Having duly discharged our duty, we would like to hand it over back to the organizers. Thank you. I think the formal part is over. If the organizers want to release us, we'll be glad. But if they want us around for a few more minutes, we'll oblige. This one is ready.
Thank you so much, Honorable Justices. Our sincere condolences to the judicial person that has lost their loved one. Maybe we could just have a moment of silence. May the soul of the departed rest in eternal peace. Okay, the next ceremony is quite exciting because your fruits, the labor of your hands get to be recognized and appreciated. But before we do that, let's give a round of applause. I don't know how heavy it should be. Let's just not disorganize other meetings, but let's truly appreciate our honorable justices. For creating the time, but above all, for being so selfless with their wisdom. Every time we come here, we are relearning and unlearning so many things, so we do not take that for granted. And therefore, next on the agenda, first of all, is we're going to have the reward ceremony. We've already announced the winners and all, but we would like to have this privilege to have pictures with the honorable justices before they go. I know these are very interesting moments for us to take on, to get inspired. Every time we see the judges robed like that, we know that one day we shall also be seated there. So the photographers, please be close. And then therefore, we're going to start with a group photo. is most appropriate. I don't know how we're going to all fit in. Do we take the key? Pardon?
Their lordships are advising that if we could do everything, then go outside and take the pictures.
The stairs, perfect, perfect. Okay, so we'll go to the announcement and rewards. Safe, where are you? Safe? I need safe. Okay, bear with us for a minute or so as we present the list for the rewards.
Okay, thank you very much, our MC. I'm going to request our Executive Director, Ms. Fatia Chiange, to come and join us here, and I'm also pleased to request the judges to come downstairs and hand over these beautiful awards to our winners. Yes. Yeah. All right, we are going to begin with the announced winner of the 10th Annual National Inter-University MOOT Constitutional Court MOOT Court competition, and that is Appellants. Maybe at this time, I am pleased to announce to their lordships that we had Cavendish University versus Uganda Pentecostal University, Kampala campus in our finals. And Cavendish University has been announced the winner. Please step in front and receive your trophy. Yes. The middle person. Congratulations. Congratulations. have that gold medals for the mooters. Mooters. The mooters are in front. So yeah, so our two mooters are also going to receive gold medals. We can All right, let's try to speed up the photo moment. Yes. And we call upon our runners up, Uganda Pentecostal University, Kampala. Crowned with silver medals. Congratulations to all of you. Yes. So Uganda Pentecostal University also received a shield as a congratulations. At this moment, I would like to, we are going to go into the certificate ceremony, and I urge you to make it as quick as possible. We are going to reward. Oh God, I wish. All right, so once we call upon your name, kindly speed up your way to the front and receive your certificate. Oteng Brian. At this moment, we are awarding all the mooters for participating. Thank you very much. Mukabire Moses. Hurry up. Give me all the names I want to read. Amumpire Masi. Onenrot Brian. Sunday Sharif, everyone I call, kindly come close. Onenrot Brian, are you here? Oh, God. Sunday Sharif, are you here? Oh. Yes, Brian. Atimango Masi Fortunate. Tumwesi Jemasi. Tumwesi JJ. In the meantime, Chigozi Herbert. Be prepared. And we have Naluoga Bridget. Okay, so I'm trying to make this quick. If I read your name, just line up, so then we shall have your photo moment. Naluoga Bridget. Sewanonda Harold. Will be followed by Winnie Chol. Sewanonda Harold. Nwamanya Angel will be following. Winnie Chol. Nwamanya Angel will be followed by Masamba Juliet. Masamba Juliet, kindly look in your steps. Masamba Juliet will be followed by Jordan Mugabe. Jordan Mugabe, kindly hurry. Jordan will be followed by Alupo Lydia Innocent. That's Alupo Lydia Innocent, will be followed by Ojambo Festo. Muhumuza Livingstone will follow. That is Ojambo Festo. Mwenda Grace. Congratulations. Muhumuza Livingstone. Is Livingstone around? Any team member or coordinator? Mwenda Grace. Livingstone, over there. Nancy Kombi Monica will be followed by Grace Bagaya. Grace Bagaya will be followed by Besisi Rapita. And then we shall have Nasije Gloria. These students were coordinated by some are their lecturers, some are their fellow students, so I would like to appreciate you too. We are going to begin with Nimsima Britton. Yes. Nimsima Britton was coordinating UPU Kampala campus. Get a list. Then we have Nakoli Maria. Nakoli Maria was coordinating Makerere University. Then we have Ankunda Melissa. Ankunda Melissa was coordinating International University of East Africa. Then we have Fancy Gender Lake. Fancy Gender Lake was coordinating Gulu University. Then we have Areba Jonathan, someone representing Areba. Areba Jonathan was coordinating Kampala International University. He sent in his apologies, so kindly pick it for him. Then we have, put it down. We have Alex Baguma. Yes, Areba Jonathan for Kampala International University. Then we have Mr. Alex Baguma. Alex Baguma was coordinating Kumba University. Okay. We have Mr. Eric Habu. Sir Eric was coordinating Uganda Pentecostal University Fort Portal campus. We have David Simbwa, was coordinating International Islamic University in Uganda, Mbale campus. We have Muchibi Sharif. He was coordinating Islamic University in Uganda, Females Campus, Kaboja. We have Nachiraya Fatuma Bogere. Nachiraya was coordinating Islamic University in Uganda, Kampala campus. And finally, we have Godfrey Ayaranga. Godfrey Ayaranga was coordinating Cavendish University. At this point, I'm going to hand over to my colleague Dorothy to reward their lordships for the job well done.
Thank you so much. The senior management is around. I think this is a noteworthy time to be available here. In the interest of time, please, let's all convene. I pray that the lordships forgive me for any injustice that may occur in terms of protocol. I'll just read what is on top of the arrangement. Thank you. Honorable Retired Justice Wilson Kwesiga. Honorable Justice Dr. Flavian Zeja. Honorable Justice Mike Chebita. Honorable Lady Justice Victoria Nachinto Katamba. Honorable Lady Justice Eva Luswata. Okay, so the best oralists and finalists, please have a moment with the justices before we go into the group one. I think this is a beautiful one. In the interest of time, please, let's try to fasten the process. Yes, just the first, yes. Okay, photo moment. Senior management of SEHAD, please join the picture. The coordinators, please. Please. Are the smiles there? Okay, great. I think that is done, and of course, as we always do, there's that historic picture by the poolside that I was reminded about. We're going to organize ourselves, and we'll head right to the swimming pool area, and the justices will find you when you're ready, aligned. I won't say so much right now. We've come to the closure. We've already wasted a lot of time in between, so I won't say so much. Just to thank you all for your commitment in this year's MOOT preparations. You can see from the feedback from the justices that you actually did well. I think what you take is preparation. Preparation is always key. Drama in court is fading. Make use of the courtrooms, and the justices are humans like us. They understand, they appreciate, and you can see the guidance that they gave us. And then most importantly, human rights deal with us. So when we're arguing, let's be as human as we can be, and try not to win, but to ensure that we are being the cohort that appreciates what human rights look like, and we advocate for them in a spirited fight of having to agree, disagree, to agree for the common good of everybody. So I appreciate all of you. And in that line and regard, I'd like to have our Executive Director, Ms. Fatia, give us a final thank you. Then we head out. Thank you.
Thank you so much, Dorothy. Our honorable judges would like to sincerely thank you for giving us your valuable time. We know that nobody, maybe very few people can get you the way you have supported us. We cannot take that for granted. We really appreciate. Thank you for the knowledge you have passed on and you continue to pass on to the young lawyers, Uganda needs them. Uganda needs your knowledge to be passed on to the young ones, for us to have lawyers that are inspired to advance health rights and also other human rights of Ugandans, especially the most vulnerable. So we really thank you for that, and we cannot thank you enough. To all our partners who are here and those who are not here, who have given us the technical and financial support, we appreciate. Our special appreciation to the Embassy of Sweden in Uganda. They are not here. They apologize, but they are one of those that normally support us with the MOOT. Then Reproductive Health Uganda, which is commonly known as RHU, through a program called Right Here, Right Now. We have Sonke Gender Justice. They are also not represented here, but they also support the MOOT. And then we have Force Feminista. We appreciate them, and also the partners we work with to organize the MOOT. Please also allow me to take the opportunity to appreciate our SEHAD staff who are behind. The preparation of the MOOT takes us some time, more than 6 months, and our strategic litigation team leads us on that. Can I please see our strategic litigation team come forward for a group photo with our honorable judges? Strategic litigation? Please, SEHAD staff, please all come at once in the interest of time. It will be too many people. Okay, let's have strategic litigation. They really lead us on this MOOT, and also the strategic litigation, they lead us on legal aid provision, so we have them here. Yes, our honorable judges, the strategic litigation team is supported by our team from the campaigns, networks, and partnerships, which we commonly call CPN. They are part of the team here today. The senior management team also support them, and they are here with us today. They have been here. We also have a finance team, which is sitting in the corner. They didn't come to join. I think they are taking care of the finances. We also have a very important team here, our monitoring and evaluation team. They have been behind the tabulations and making sure that we have a transparent process in terms of the marks, the scores, so we want to appreciate them. We also have a team of our communications team, so we have been live streaming. This has been everywhere live streaming, so when you see yourselves on social media or on TV, we have our communications team that works closely with this team to make this happen and popularize it. We also want finally to appreciate the team of magistrates that presided over the preliminary competitions yesterday. They are not here with us, but would like to appreciate them in absentia. Finally, we want to appreciate you all, the MOOTers, the coordinators, the lecturers. We could not have done this without you. Thank you so much. We really hope that you can take this knowledge and build it further. From SEHAD, we offer internship to especially the best team for you to continue grounding yourselves on health policy and the law. The team here will write officially to you to advise you in terms of the detail for that offer, but please know that that's an offer from us to continue grounding you on issues of health policy and the law. Thank you so much again.